sanctity going through that.
Welcome everyone. Thanks a lot for staying with us. You're watching Plain Speak with me, Shivani Gupta. A constitution bench of the Supreme Court heard a batch of petitions seeking legal recognition for same-sex marriages in India for a second straight day today. About 20 such petitions have been filed in the apex court between 2020 and 2023. The petitioners are demanding legalization of gay marriages as the law denies them matrimonial and retirement benefits. Today, the arguments continued in the direction that decriminalization of homosexuality is not enough and gays shouldn't be treated as less just because of ascriptive characteristics. Remember, the centre government has opposed these petitions on several fronts. Most importantly, that it is not a domain of the courts but of Parliament. That hasn't stopped the courts from conducting the hearings though. But today, the court did respond to the government's contention that same-sex marriage is against Indian culture and an urban-elitist concept. The Supreme Court said that the government doesn't indeed have any data to prove so. It's just a belief as more urban people are coming out of the closet. Even the petitioners argued that calling it elitist ignores the struggles of the LGBT community. But interestingly, the court has mandated that while they will look into the civil union of gay couples under Special Marriage Act, they will steer clear of personal laws. Now, that's a distinction that may be okay for now for the purpose of this hearing, but will not be limited after all. Marriage is one of the most fundamental religious institutions. Let's not kid ourselves. Every religion has personal laws governing this aspect of life, and then divorce, succession, inheritance, adoptions, etc. In a country like India, touching these laws is almost impossible, even for the Supreme Court. So has it found a convenient way to skirt the issue and leave it for a later bench to deal with? Is dealing with same-sex marriages only from the prism of special marriages inherently myopic? After decriminalizing of gay sex, allowing gay marriages was going to be a natural progression. Frankly, whether you're for it or against it, stopping it is going to be virtually impossible. And with it, issues like adoption, childbearing and child-rearing rights of gay couples. So if gay marriage was to be legalized, let's say, will it not fundamentally lead to opening up of a Pandora's box from the personal laws front? And wouldn't it have been better to deal with it now than later? We'll take that question to our guest joining us in just a bit. First up, let's also tell you more about the central government's fresh affidavit in the Supreme Court. This is what it says. The plea urges Supreme Court to make all state governments and union territories party to the petitions seeking recognition of same-sex marriage. Centre says that concurrent list in the 7th schedule of the Indian Constitution includes marriage, and it also pertains to divorce, infants, minors, adoption, wills, incestacy, succession, joint family and partition. Thus, consultation with all the states is necessary for adjudication of the petitions. Centre says the rights of the states, especially the right to legislate on this subject, will be affected by any decision on this subject. In fact, the Centre added that it has already started the exercise of consultation with all states, even in the absence of a notice to them, and they argued or pleaded in the alternative that they are not sent a notice. The Centre should be allowed to finish the consultative process with the states, obtain their views, apprehensions, compile the same and place it on record. In fact, the Centre had brought up this issue yesterday as well. Just for context, here are some of the key submissions that the SG Solicitor General made yesterday on the first day of the hearings on behalf of the government. First thing, creation of socio-legal relationship of marriage is the domain of the Legislature. This subject is in the concurrent list. All states may not agree. The SC also brought up the issue of maintainability, adding that there are repercussions if the court decides on this. He added that they should be given time to consider to what extent the government would want to participate. And finally, the SG said, this is not an issue that few minds on each side and a bench can decide. The court was not inclined to quash the petitions on the ground of maintainability, with CJI D.Y. Chandrachud interjecting the SG and stating that the nature of the SG's preliminary objection depended upon the canvas of the petitioners. And he added that once we have a picture on what is the canvas they're arguing on, we may tell them what is the canvas we want them to argue on. In other case, they've brushed aside the maintainability issue for now. Now, what was interesting is that the court clarified that for now, it would be limiting itself to the ambit of Special Marriage Act and not personal laws. The CGI said that we can at this stage steer clear of personal law, adding that it may not be necessary for the court to get into personal law at this stage. Now, even to this, SG Tushar Mehta objected and said that whether the court liked it or not, the hearings would necessarily affect personal laws. There is just going to be a rippling effect. What was also interesting is how the court decided it will not go into personal laws at this stage, despite the insistence from senior advocate Menika Guruswamy, representing a petitioner who had sought an expansive reading of the Hindu Marriage Act to include queer marriages. She said the Hindu Marriage Act is not an issue necessarily of personal law, it's a statutory law. It has in the past allowed something that was not permitted in sacramental Hindu law, like intercaste marriages, sagotra marriages, etc. But the bench did not seem eager to entertain arguments on, marriage equality in the Hindu Marriage Act. At this juncture, the CGI said there may be some amount of wisdom in going about our tasks in an incremental manner, because otherwise, how do we confine ourselves to Hindu Marriage Act alone? What about Parsis, Jews and Muslims? So they decided they will not get into any of it. A reminder of the main submissions by advocate Mukul Rohatgi on behalf of the petitioners. He argued that now homosexuals have the same right as heterosexuals after the decriminalization of gay sex. He added that marriage should be declared a fundamental right for gays too, adding that the state cannot say that we can just leave you alone now because we've removed 377. We want to enjoy the full extent of our rights. Remember, petitioners also argue that they can't avail for a lot of benefits like insurance that other married couples can. He also added that while decriminalization gave them privacy in their homes, they also want dignity in public space. And finally, that the state should allow gay marriages to be recognized under the Special Marriages Act. Senior advocate Rakesh Dwivedi, while praying for states to be included as parties in these petitions, also brought out the counter view to same-sex marriages. He argued that gay couples cannot be treated at par with heterosexuals or have absolute equality. He added, heterosexual couples perpetuate the human race. It's a core component of these unions, if not the entire component. Marriage amongst heterosexuals is not the gift of law. In other words, it doesn't happen because the constitution allows it. It existed since the Rig Veda or from time immemorial. Same-sex is not a new phenomenon, he said. It existed earlier too, just that they didn't claim equality. And finally, that the two unions are different, they cannot be put on the same pedestal. The big debate that's coming up, gay marriage legalization. If we were to move into that direction, at this stage, leaving aside personal laws, will that not lead to opening up of a Pandora's box? Let's go across to the guests who are joining us. Abhijit Iyer Mitra is one of the petitioners in this case, also senior fellow, Institute of Peace and Conflict Studies. Shashank Shekhar Jha is a senior lawyer who's appearing in this case. Nikhil Mehra is also a lawyer, and Professor Geeta Bhatt, academician, is also joining us. I am going to discuss some of the comments that the CGI made pertaining to gender and biological sex, but that's a little bit later because that also grabbed a lot of headlines. First up, I just want to focus on the arguments that have been made in court. Abhijit, what do you make of the decision by the court to not go into personal laws? Is it just, deflecting a complex issue that arises out of legalization of same-sex marriages for a later day and deferring it as the court almost accepted?
Look, I don't know what their personal motivations are. It's probably to, follow a path of least resistance or whatever. My petition is for the Hindu law specifically. It isn't under the Special Marriage Act. Yeah. Because if you read the Hindu Marriage Act, it says husband and wife. It doesn't say man and woman. So we're very clear it refers to gender roles and not to genders, to marriage roles and not to genders. Right. Now, as for why the court does things, this is very much Ram Bharose. Nobody really knows why the court does what it does. It works in mysterious ways.
But do you believe that we fundamentally cannot move on as a society unless we do grapple with the concept of personal laws? Because fundamentally, there may be individuals who want to get married amongst the LGBT community, as ordained by their religions. That may be a desire.
Right. So, see, the thing basically comes down to, first of all, this argument that somehow marriage laws, personal laws included, are necessary for, are meant for the purposes of procreation, that marriage is meant for procreation. I mean, really? I mean, can you not procreate without marriage? I mean, does marriage confer a certain fertility on you that you suddenly get fertile and can give birth to babies after the Marriage Act and can't do it outside of marriage? Rubbish, right? A marriage is any law, including a personal law, is basically a contract. It's a contractual law. And the point of entering into that contract is once you enter contract, as per contract law, you have certain responsibilities, certain obligations, certain privileges, and certain liabilities. Right. It is to formalize that entire system because a lot of things in this country, like financial inclusivity, depend, where married couples can get certain privileges, work privileges, loan privileges, bank privileges, etc., etc., etc. It is tied into a whole load of things like financial inclusivity, child protection, etc., etc., etc. So you fundamentally need that to extend into all laws, not just a separate standalone as in the Special Marriage Act.
But can I understand from you, is it essential for petitioners like yourself to be allowed to the right to, in your case would be child rearing, so I'm guessing adoption, but let's say in the case of a lesbian couple, childbearing as well. Is that essential, or are you fundamentally only looking at certain benefits, economical and otherwise, that come with being recognized as a married couple?
See, it has to do with the protection of the child. Because you tell me, how does inheritance work otherwise? Assume you're born into a family with the Hindu Marriage Act and you then get married under the Special Marriage Act. What inheritance law then applies to that child? We already have a whole gamut of cases. If you go to the family courts that have arisen, inheritance cases and things like that have come about precisely because of this conundrum.
No, but
right, the children who get adopted need to have that security. So it's not just benefits. Understand, benefits, economic benefits is one thing. Security is a completely different thing.
I'm asking you this question because the court, you're taking it for granted that obviously this will lead to certain rights about childbearing and child rearing. But I'm asking you this question because it almost seems like the court is skirting that question. For now, they're only looking at quote-unquote legalization of this union. They're not even going into whether they will be later allowed to have kids, adopt kids, bear kids, etc. That is fundamentally what I'm trying to understand from you. Would you have rather the court went into all of this than skirt this for now?
Look, the issue in front of the court is very, very simple, right? It's a question of equality. Bas. These are questions, the questions that you are asking, Shivani, are for the rest of society to sort out and for the government to see to it that there's a synthesis of the laws once it has been ratified by the courts. Okay. All they have to decide on is marriage equality required at this time? And is it feasible to be given at this time? Bas, nothing more.
Okay. Shashank Shekhar, I want to understand from you, SG Tushar Mehta did make this point that, even under the Special Marriage Act, there is a clear distinction that marriage is a union between male and female. I'll get into that whole discussion of what transpired because of that comment. But what do you make of the fact that the courts are now saying, okay, let's just look into Special Marriages Act. It is the easiest thing to do for us. It can be easily made gender neutral and will not touch personal laws because clearly that's a fire pit that even the Supreme Court doesn't seem to want to get into.
Namaste Shivani ji and every other fellow panelist. Shivani ji, first of all, before going to your question, we need to understand that according to Hindu Marriage Act and Hindu laws, marriage is not a civil contract, but it is a sacrament. Yes. It is not merely a rituals, but an entire institution, and that is why we have separate legislation for the same, and it has been the objective of the parliament altogether. Now coming to your second question, See, Supreme Court has clearly stated that it will not interfere the personal laws, because as far as society is concerned, we have not come to that stage where we are even ready for the UCC. So when there is no UCC, you cannot expect that one community will be transferred and other will not. Now coming to the Special Marriage Act, see, we need to understand the objective of Special Marriage Act. I will just quote you section 21 of the Special Marriage Act, just one provision, and you will know that the objective of Special Marriage Act was always for heterosexual community. You cannot expect now that judiciary should interpret it in such a way that it will transfer or change the nature of the Special Marriage Act. And if it does so, then what will happen to other laws which will be affected by this? See, we need to understand that in India, currently, the marriage for women is 18, the age for marriage for men is 21. So how will you differentiate? How will you take that? If you will take 21 or 18, because according to special it is 21 at a few places, but then there are other laws, for example, inheritance. How will you do with adoption? How will you do with other property rights, etc.? So I don't think that without listening to, see, one thing is that Supreme Court should not entertain this petition in the first place. This is a case of completely misguided intentions, and the priorities are not straight. But even if Supreme Court is entertaining this, I don't think how they are doing it without even listening to the states and union territories. Remember, marriage rights are completely under the duty of both state and center as per constitution. So if there is a talk about constitutional morality, you need to follow the constitution. According to constitution, this falls under the concurrent list, which means both state and center will have to abide by it, or you will have to hear both the sides.
No,
Suppose
on that, I get your point.
And says,
no, I get your point, but on that, I don't think the Supreme Court has refused that they will not allow the states to be party. Let's give it time. But on personal laws, they have almost said that they're not going to go into personal laws. So let me just stick to that. And I take your point that, of course, this is on the concurrent list. The states will have to be made party. But Nikhil Mehra, I want to bring you in as well. What are the dangers associated with doing what the Supreme Court is doing, but restricting it to just Special Marriages Act? Shashank is saying that even the Special Marriages Act cannot be changed like this to make it compatible for homosexuals from heterosexuals, and then completely sideline personal laws. So ultimately, socially, you will still not have legal sanctity, because, most of the personal laws will still not recognize gay marriages. So will that not be only half a battle won, even if it was to be legalized? I'm assuming if it is to be legalized.
Why is that only half a battle won? It's still a marriage. I mean, there are Special Marriage Act marriages within heterosexual communities in India everywhere. So why would that be half a battle won? Look, at the end of the day, the issue is that when it comes to religious laws, the court doesn't want to sit in interpretation of the religious laws. So Abhijit, for example, cited to an argument that they are raising in their petition that the Hindu Marriage Act is an amendatory act and has therefore amended various practices and rituals of Hindu law, but it has not sought to redefine marriage. It has not sought to redefine facts. It has not, for example, redefined an HUF. It may have ended the concept of an HUF, but it doesn't create a legal fiction as to what is an HUF. So the issue here is, can you, as the court, simply sit in interpretation of ecclesiastical texts and turn around and say, look, we interpret these texts to mean that gay marriage is or is not allowed? And I would venture to state it would never want to do that. So when the CJI says this is an incremental step, what he's perhaps saying is this. When gay marriage became legalized in the United States, it was after a decades-long movement, which was won at various legislative levels. And by the time the judgment came from the Supreme Court, US Supreme Court, it came on the footing that we see a larger acceptance on account of legislation that has come through various states and through various local bodies. And after that, the court says, now we deem that there is a greater acceptance and we hold that this is a basic fundamental right as recognized by society.
But can I ask you something here? Is there acceptance of that larger, greater acceptance even for Special Marriages Act now?
That is perhaps what the Supreme Court is trying to do, that now what you have is a state-based, a state-sanctioned concept of marriage. And there they can apply the concept of equality more efficiently, and they will test that concept. Perhaps they felt they cannot even begin to test it in the context of ecclesiastical law.
But I'll push you one more time. Is that not the easy way out? They're just not touching what is more cumbersome and that will invite
So
greater backlash.
let me pose the question.
They're choosing the easy way out, as Abhijit
Right, Shivani,
said.
then let me pose the question separately to you.
Yeah.
And in fact, to the activists, isn't it an easy way out to go take a petition to the court instead of actually creating social inclusion within society, having the movements, having the political power to say that, yes, everybody generally accepts. If you
No,
want
that's
to
a
go through the
question I
courts,
was
the
going to
court
ask
will
both
come
of
and
you.
say-
That's a question I was going to ask both of you, whether this should done by via courts in the first place. But Abhijit, you want to answer that?
See, my thing is very clear, Shivani. The Hindu Marriage Act simply does not state man and women. We're not asking for a change of the law, or we're not asking for anything new. Remember, before 1955, there was no such thing as a Hindu Marriage Act at all. It depended on each village, on each pujari, if he decided if he wanted to solemnize a marriage or not. Now, I'm going to read out the first part of the Act, Conditions for Hindu Marriage. A marriage may be solemnized between any two Hindus. It doesn't say man or woman. Between any two Hindus if the following conditions are fulfilled, namely, neither party has a spouse living at the time of marriage. At the time of marriage, neither party is incapable of giving valid consent in consequence of unsound mind. Capable of giving valid consent has been subjected to a recent attack of insanity. The bridegroom has completed 21 and the bride has completed 18.
But doesn't bridegroom mean something?
These are all marriage roles.
No, I'm sorry,
come on,
every
Abhijit,
single religious law says the
reading?
same thing.
Is that not a convenient reading? Husband, wife, bridegroom means something.
But man and woman does not say man and woman anywhere, no?
Yes, because the context didn't demand it.
It does not say man and woman. It does not say man and woman.
Yes, Nikhil.
So here's the thing.
Our
thing is very
let me just rebut this for a moment.
Yeah,
the Christian Marriage Act says a Christian marriage is valid when it is between two Christians. It does not say man and woman. Are you going to tell me the ecclesiastical rules of Christianity say that you can have marriage between men and women, between two men? That didn't even arise in the US. It was compelled. So the short answer to Abhijit, I'm in support of his proposition. But to support his proposition, the short answer is you say that a pujari can marry two Hindu men. Let him marry two Hindu men. Let him give a certificate of marriage. Let somebody else come challenge that certificate of marriage. And then you can come back and say, look, it is recognized under Hindu law. That is why a person who is knowledgeable on the fact, authorized by law, has conducted a marriage. You want to go the other way around. This entire exercise sometimes feels like the tail is trying to wag the dog.
Okay, but can I ask Abhijit very quickly the question before I go across to Geeta Bhatt as well? A lot of people are genuinely asking the question, Abhijit, if this is indeed, unfair to get these rights which are purely in the domain of the legislature via courts, just because the courts, some may feel are favorable to these causes. Is it not right to first build a movement, social acceptance, and then the laws to naturally follow versus this?
So I would have preferred it if it had come from the legislature, right? The issue is what really, you tell me, how do you build the pressure on the legislature? LGBTQ people don't account for a vote bank, right? We don't have a vote bank. We're not loyal to any party or whatever. So how do you create the social movement for it? It's a minuscule micro minority. So how do you do that? We're not interested in becoming anybody's vote bank. Right. So how do you do it? Going to a court is one way of pressurizing the government. Because see, it forces the government to then act one way or another.
Okay.
Right. Now, the question here is society ready for it? Now, that's a very open question because the whole point of a fundamental right is it is not subject to legislation. A fundamental right is fundamentally fundamental. The right to equality is a fundamental right.
But is marriage a fundamental right?
You can't legislate a lack of equality.
Okay, I want to come to that question also. Is marriage a fundamental right, which we will know one way or the other by the virtue of this verdict? But Geeta Bhatt, I want to come to you. There is, even the courts seem to accept, the SG referred to it, that, you're going to go into this direction, you're going to have to deal with personal laws at one stage or another. There will be questions that will arise in society. There are several laws in the country which are gender specific. All of those laws will have to be harmonized. Are we opening a Pandora's box before we are socially and legally ready for same-sex marriages?
Shivani, you see, when the observation in the Honorable Supreme Court were made that, there is no absolute concept of a man or woman. If we are going to fundamentally redefine this, then definitely there are going to be, larger ramifications to it than just saying that we can limit it to just the Special Marriage Act, making some change in the Special Marriage Act. Because we do need to realize that at present there are so many, you're saying that there is fluidity in sexuality. Okay, in a perception of having that a particular gendered perception, there could be a fluidity. But in terms of biologically defining a man or a woman, there cannot be any fluidity.
Okay, I'll come to that a little bit later. Geeta, but I'm going to discuss that a little bit later. But fundamentally, I'm trying to understand from you. What are the impacts you see socially, legally of legalizing same-sex marriages? Are we ready for it? And then how do we reconcile personal laws with it? Do you see that in the realm of possibility via government, via judiciary, that personal laws will be asked to fall in line?
Shivani, when it has already, that observation has been made by the other panelists, that when you are, the way you define marriage, marriage when you are defined in terms of the Hindu Marriage Act, where it is, it is a sacred union, it is a sanskar, right? But if you are looking at the Muslim personal law, it is a contract. So the way you are defining marriage is something which is varying between various communities. When you come to the Special Marriage Act, the Act was created specifically for the purpose when people from different different faiths, they want to come together in a union, so there has to be a special act. So if you are when an act which has been created with this specific intention, when you are going to tamper with it, definitely how you can isolate that to which particular faith a particular individual is belonging in terms of a legal perspective. Okay. It will be something which will be very difficult. You need to address that issue. You cannot isolate that issue by saying that just by making a change from calling a man or woman to spouses, that change is going to happen. Please do also consider that there are certain acts like the Sexual Harassment at Workplace Act 2013. Similarly, there are various acts which are gender-based.
I know exactly what I'm referring to. Even if you change Special Marriages Act, but the moment you legalize same-sex marriages, you will have to redefine certain laws that are gender-specific within a marriage or in context of a marriage. Before I move on to my next subject, Nikhil, I very quickly want to understand two very quick things. One, is it in the domain of the Supreme Court to quote-unquote, as Geeta Bhatt said, tamper, or I'll say change the Special Marriages Act? And secondly, can marriage be considered or ordained a fundamental right?
So yes and yes. Firstly, as to the Special Marriage Act, that becomes an interpretative issue. As realities change, definitions can change in the context of that reality. To test whether marriage is a fundamental right or not, let's say tomorrow Parliament passed a law that says nobody is allowed to get married. My proposition is that law would be struck down under Article 21, that is right to life. So therefore, it would be a facet of the right to life.
Okay. All right. Let me just request some of our guests to continue with me. Yes, Abhijit, you want to say something?
Shivani, just one quick point. Show me where in the Hindu Marriage Act does it say that marriage is some great sacred sacrament.
The Hindu Marriage Act may not say it, but Abhijit, we all know that Hindu Marriage Act came into being under certain circumstances. Hindus don't consider marriage to be a contract. There is no term for divorce.
Can I answer this, please? This is a little bit of legal confusion.
Can I come for just 10 seconds?
May I please?
Okay, all of my guests want to come in. I have limited time because I want to discuss the CGI's comment on gender fluidity also. Yes, very quickly, Shashank, please answer. Very quickly, but
may I please?
Yeah, 1 minute only.
Yeah, I will just, all those observations which is saying that Special Marriage Act as well as Hindu Marriage Act can be defined in such a way that two same-sex couple can be married because it is not written in the act itself. They need to understand that all these laws have come after the customary laws which has already been prevailed in this country. So Hindu are marrying in such a way has been done throughout 1,000 years of the history of India, and same is been taken into Special Marriage Act also. So when you are defining something and making a law, you need to understand that the same thing has come to the act as of now. So you cannot say that, oh, okay, someone is saying that you define it in such a way and Supreme Court can do it. No, they cannot do it,
Okay.
and that is why where customary law is in place. And that
Okay.
is what Austin says, that is what has been said by the customary laws by
Okay,
everyone
Geeta Bhatt,
across
very
the globe.
quickly, Geeta Bhatt, is
Yeah,
it not a
Shivani-
contract in Hindus, amongst Hindus?
Shivani, I want to put forth one more perspective over here is that if any such change happens, it is women are going to be, those who will be at the receiving end of it, because there are various kind of, privileges which women have been getting in terms of whether it is respect to whether getting leave for pregnancy, for example, I am saying. There will be various issues in terms of there is a reservation bill. For women, which is already there pending for a decade, almost more than a decade now.
Geeta Bhatt, you're
Now,
confusing
who
this
is
with
going
gender
to-
fluidity. I'm not going into that. Very quickly, Nikhil, you wanted to respond
Yeah,
about
please
the
understand
Hindu Marriage
Hindu
Act
Marriage
question.
Act is an amendatory act. The purpose is not a displacement in entirety of all Hindu custom and rituals. It does not seek to define marriage per se. It does not seek to alter those base common concepts that arise from Hindu custom. And Hindu custom says that Hindu marriages are a sacrament. That is why you take the Saptapadi around a fire. That is the whole concept of the Hindu marriage.
And today
So we
divorces
shouldn't be
are
confused
allowed,
about
but
this. Hindu marriages are
traditionally
not
there's no
contract.
concept of a divorce in Hindu marriage.
That it did not exist. You're absolutely
Exactly.
right. It was introduced. That was later, but that does not redefine the concept of the basis of the marriage.
Okay,
It
I
was
leave
introduced.
this
Absolutely correct.
point of our discussion here. We'll see how the hearings go. But